Reese versus Bureau of Alcohol, Tobacco, and Firearms and Explosives.
Good morning, Your Honors, and may it please the Court, John Ohlendorf for the appellants. 18 to 20-year-olds are considered legal adults for virtually all purposes, and certainly for the purpose of exercising fundamental constitutional rights. Yet 18 U.S.C. 922 B1 and C1 severely infringe their ability to defend themselves and their families with the most popular firearm chosen by Americans for self-defense. Under the Supreme Court's recent Bruin decision, the constitutionality of that restriction must be assessed based solely on the Second Amendment's text and its history. Now, the plain text of the Second Amendment plainly covers the plaintiff's proposed course of conduct. Plaintiffs are Americans, and they wish to engage in the most fundamental prerequisite to keeping and bearing arms, acquiring those arms in the first place. That shifts the burden to the government to, in Bruin's words, justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. Now, the government tacitly concedes that no state imposed any age-based firearm restriction of any kind until 1856, over 60 years after the Second Amendment was ratified, and even a dozen years after that, when the 14th Amendment was ratified, the government can identify only two such regulations. Both of those come from the antebellum South, a dubious place to look for enduring constitutional traditions. One applied only to men, and the other was upheld as constitutional only because the state adhered to an outlier, militia-centric view of the right to keep and bear arms that the Supreme Court repudiated in Heller. The government's age-based handgun ban is thus inconsistent with the Second Amendment's text and history, and the district court's decision should be reversed. Now, Your Honors, as I say, the first step of the Bruin inquiry is to look at the plain text of the Second Amendment, and we submit to you that it does cover the plaintiff's proposed course of conduct here. And I don't take the government to dispute that the Second Amendment right to keep and bear arms does implicitly but necessarily include the right to acquire those arms in the first place. But the government does argue that Section 922's age-based limit should be viewed by the court as outside the Second Amendment's textual scope because the government suggests that it is a condition or qualification on the commercial sale of firearms, which the Supreme Court in Heller suggested in dicta could be presumptively constitutional. Your Honor, no court that I'm aware of has ever accepted that proposition that 922 is completely outside of the Second Amendment's text under this purportedly presumptively constitutional type of measure, category of measures, and several courts have rejected that proposition. The government cites this court's now abrogated decision in the NRA case, but in NRA, the panel actually said that it is not clear that 922's age-based limit is the type of condition or qualification on commercial sale that the Supreme Court had in mind when it penned those words. And of course, the panel went on to uphold 922B1 only under an application of intermediate scrutiny. The government also cites the 11th Circuit's decision in the Bondi case, but as the government's reference to Bondi is forced to acknowledge, Bondi too upheld 922 not as outside the Second Amendment's textual scope, but rather through we would submit very mistaken and misguided application of Bruin's history and tradition inquiry.
What do we make of Justice Alito's concurrence in Bruin that says our decision does not expand the categories of people who may possess a gun? Federal law generally forbids possession, prohibits the possession of a gun under 18 and bars the sale of a handgun to anyone under the age of 21.
I wouldn't make much of that reference, Judge Elrod. I think certainly Justice Alito is correct that the court's decision in Bruin did not address the who question, right? The Supreme Court's decision in Bruin does not expand nor contract the types of people who come within the protective ambit of the Second Amendment. But I don't think one can read that statement by Justice Alito as in any way passing upon the constitutionality of 922 B1, or on the question of whether it constitutes a condition or qualification on commercial sale.
Do you have any comment on the amicus brief's discussion of the time of the 14th Amendment incorporation and the Paul Clement, Justice Thomas dialogue in that regard?
Yes, Judge Elrod. So the first thing I would say is I think that that interesting academic theory has no application in this case, since this case concerns a federal prohibition. I think it would be quite unusual and completely out of step with Supreme Court and circuit precedent to look to 1868 to discern the meaning of the Second Amendment as applied to the federal government, which was bound by that amendment when it was ratified. Second, even in the context of state regulations, to be honest, I don't think much of that theory. I think under governing Supreme Court precedent, there are two propositions that are clear. The first is the court has always looked to, as I said a moment ago, has always looked to the date of ratification, 1791, to discern the original meaning of the Bill of Rights as applied to the federal government. And number two, there is a long tradition going back to the Malloy versus Hogan case and up through McDonald and Ramos versus Louisiana of the Supreme Court very clearly establishing that there is zero daylight between the application of the Bill of Rights to the federal government and the state government. So I think it follows just as a matter of precedent from those two propositions that the historical touchstone for the inquiry under Bruin into original meaning must be 1791, not 1868.
What exactly do you want us to do?
Well, specifically, I want you to reverse the district court's opinion, Judge Elrod, and to hold that Section 922B1 and C1 are unconstitutional under the Second Amendment's text and history because 18 to 20-year-olds are among the people protected by the Second Amendment, and the government has failed to come forward with a sufficiently analogous historical tradition that would justify that age-based restriction.
What about the argument, to the extent it's being made, that their 18 to 20-year-olds are especially dangerous because they lack impulse control because of their frontal cortex is not fully developed, etc.?
So I'd make, I guess, 2 points in response to that, Judge Elrod. First of all, that is precisely the type of argument that under Bruin the courts are no longer authorized to undertake. It is not. It is clear after Bruin, if it was ever unclear, that it is not the job of this court to examine the policy wisdom of Congress's restrictions on firearms and attempt to somehow weigh that policy wisdom in determining whether those restrictions pass constitutional muster under the Second Amendment. The second point I'd make, Judge Elrod, is even if that were within this court's ambit, Section 922B1 is a very peculiar way to address that supposed policy concern, because the effect of Section 922B1 is to take this group of Americans, 18 to 20-year-olds, who Congress apparently was concerned about engaging in the clandestine purchase of firearms, and to force them to only acquire firearms clandestinely, to force them out of the regulated, licensed market of ordinary licensed firearm dealers into the unregulated secondary market, essentially to force an 18-year-old to walk back out of the Cabela's store and into the parking lot to buy their handgun from somebody's trunk instead of the licensed dealer in Cabela's who would run a background check and so forth. So I don't know that concern really ever would have moved me, Judge Elrod, but certainly after Bruin, it is simply not something that this court is empowered to consider. So, as I say, I do think it is clear as a matter of text that this type of restriction is not a condition or qualification on the sale of commercial firearms in the sense that Heller used that phrase. The Third Circuit in the United States Marzarella case in fact, said that conclusion would be untenable under Heller because it would seem to imply that the government could simply ban the commercial sale of all firearms and then say, well, that restriction is just outside the scope of the Second Amendment because it's a condition or qualification on commercial sale. And I think that the Fourth Circuit's decision in the now vacated Hirschfeld case kind of gives us the reason why this argument is untenable. A condition or qualification on commercial sale is a hoop that the seller has to jump through in order to engage in the commercial sale of firearms. It has to become licensed. It has to, undertake to do background checks. It has to keep records of its firearms transactions and that sort of thing. Section 922B1 is instead an insurmountable infringement on buyers, on a whole category of buyers that prevents them from obtaining the quintessential self-defense weapon in the ordinary way. There is no qualification that my plaintiffs can meet, no condition that they can satisfy.
But your brief repeatedly makes the argument or responds to the government's argument that 18-year-olds were widely considered legal minors at the time of the founding, and you say, well, that's not true anymore. But aren't you engaging in the same updating of the history that you accuse the government of in other respects?
So I don't think so, Judge Jones. The way that I conceptualize, the response that you've mentioned from our briefing is it's really an application of the analogical reasoning that Bruin requires, right? So Bruin says that when you're looking at historical analogs, you have to weigh the how and the why, right? You have to determine is it the same type of burden as historically was imposed on Second Amendment rights, and does it have the same type of justification? And the restrictions that the government cites, mostly from the late 19th century, all applied to legal minors, Judge Jones. And I would submit to you that is a different type of burden, both in the how and the why, than Section 922B1, which applies to legal adults. As to the how, when the government prevents my 11-year-old daughter from carrying firearms, that's a different type of burden on her rights because the government allows myself and my wife to bear arms for self-defense if we so choose to, and we can protect her right to self-defense in that way. It's very different when the government burdens the right of an 18-year-old to bear arms. The 18-year-old, she may be living alone. She may have to commute through dangerous areas for work or for school. She faces the same types of acute needs for self-defense than any other adult does. So I think the how is different. The why is also clearly different because the basis or justification of these historical laws was based on the minority status of the people to whom it applied.
This argument you're making now, and I know you responded to Judge Jones, but it seems off the mark from the two-part test we're supposed to be applying.
So I think Judge
what a woman living alone in an apartment might need.
I don't think that's right, Judge Barksdale, because Bruin does tell us in the second part of that test to weigh the how and the why, the burden on the rights of self-defense, rights of armed self-defense, and the justification for that burden. So that is part of the Bruin inquiry. Now, I would say this is this is our secondary response to these 19th century laws, right? So our principal response is that they're too little and too late, especially when weighed against the overwhelming founding era evidence that there were zero age-based restrictions on Second Amendment rights for over 60 years.
Has there been any significant development in historical understanding in regard to this issue since our court debated this back in the previous NRA case?
Your Honor, I don't think in terms of the history that's available that there's much new. I think the parties are, rehearsing the same set of 19 laws that were, discussed in your dissent from denial, Judge Jones. They're citing the same history of militia laws as were discussed back then. I do think the focus of the analysis has very clearly changed, right?
Right.
The Bruin case fundamentally overturns the focus of the analysis that the panel decision in NRA was engaged in.
Do we need to wait on anything going on in the Supreme Court?
I don't think so, Judge Elrod. Of course, the Supreme Court has granted the Rahimi case. We do think Rahimi is supportive of us in a couple of respects. For example, it adopts 1791 as a critical date. But Rahimi is certainly not the only precedent for those propositions. I think it's unlikely that what the Supreme Court is going to say regarding those subject to domestic violence restraining orders in Rahimi is really going to have any bearing on the age-based restrictions at issue in this case. Thank you, Your Honors.
All right, you have time for rebuttal. Thank you. Mr. Hazel.
Good morning, Your Honors. May it please the Court, Stephen Hazel for the government. History shows that Congress may empower parents to supervise 18 to 20-year-olds' access to handguns. For as long as legislatures have written down age qualifications for arms, they have done exactly that. There is no evidence that any historical court, legislature, or commentator ever cast doubt on that widespread practice. So while Bruin's historical approach may give rise to some difficult questions, this isn't one of them. The Court should affirm. The federal restrictions at issue here are limited in the same way as historical laws. They empower parents to supervise 18 to 20-year-olds' handgun use. They're focused on handguns, and they're focused on the same age qualification as many of the historical laws that we've cited. Within a lifetime of the founding, 20 different jurisdictions adopted laws that parallel the restrictions at issue here. Those are restrictions from all across the country, and again, they are incredibly close analogs to the federal restrictions that are challenged today. Courts upheld those laws, commentators approved them, and the public endorsed them. The rare challenges to those laws were rejected. One of the commentators that the Supreme Court cited in Heller, Thomas Cooley, accepted that those laws stated a viable restriction on the right to bear arms, and public opinion from the time showed that they were endorsed by the public. There's nothing on the other side. Plaintiffs in their briefs and today, they haven't pointed to even a single court decision at the time suggesting that all of those laws...
Why would there have had to be a court decision?
Your Honor, because these 20 laws across the country were enforced... I'm sorry to interrupt, Your Honor. Because these 20 laws were enforced across the country for most of American history, the fact that there was no court decision calling those...
When was the first of those laws?
The first were from of these exact analogs were from the 1850s, Your Honor.
1850s?
That's correct, Your Honor. So within the lifetime of the founding, and as how...
That's a pretty generous way to put it. That was at least two long generations after 1791.
Your Honor, so Heller actually, in talking about this 19th century evidence, not only describes it as a critical tool of interpretation, but actually says that those born and educated in the early 19th century, so the people who would have been in legislatures, state legislatures at the time of these laws, their views would have been instructive as to the meaning of the Second Amendment and the right to bear arms. And again, there's nothing on this other side. There's no court decision. There's no legislative debate in any of these cases about whether...
Well, there's none except what there was a comment in Heller about the Militia Act relating to 18-year-olds.
So, Your Honor, to the extent that plaintiffs are relying on militia laws, Heller says that the Second Amendment right is unconnected to militia service, and so they're relying on one of the few sorts of history that Heller...
But that's not right. Heller says that there was a need for a militia and that it was understood that the militia required the militiamen to furnish their own weapons for the most part. It's an individual. I mean, you're turning Heller upside down if you say that the main purpose of Heller was militias.
So, Your Honor...
Or divorce from militias.
So, Your Honor, 2 points. First, Heller makes clear that in deciding the scope of the right to bear arms, we don't look to the scope of the militia. That is ruled out by Heller, and it's confirmed by Bruin, which does a great deal of historical analysis and certainly does not rely on militia laws. Second, even if the court were to consider militia laws, plaintiffs' theory that being required to participate as part of a well-regulated, supervised militia to drill in that supervised environment, that does not at all imply a right to obtain a handgun outside of that supervised militia context. The one just does not logically follow from the other. And in fact, many of the militia laws that plaintiffs rely upon emphasize that parents would have to be the ones furnishing 18 to 20-year-olds with weapons. So they recognize that 18 to 20-year-olds wouldn't necessarily have access to guns on their own, and certainly wouldn't necessarily have a right to access those weapons.
Well, culturally, of course, you're speaking about a country which then had about 3 million people, only a handful of whom lived within towns or cities, most of the rest out in the country. And of course, they had weapons. So, I mean, that doesn't, the fact that parents might have to supply a weapon means just that somebody had to supply a weapon. It doesn't say anything in particular about whether 18-year-olds were prevented from purchasing weapons.
So, Your Honor, it's certainly true, as plaintiffs say, that we haven't cited any founding era age qualifications. There were no age qualifications that we're aware of at the time on even 5-year-olds. Everyone agrees that they can be disarmed, and as long as legislatures have written down an age, they have drawn the line at age 21. That's true not just in the historical sources that we've cited, but today we have, of course, this 50-year-old federal law before the court. We have a substantial majority of states that have also chosen to draw the line at age 21 for various rights related to arms as well. So what plaintiffs are asking the court to do here is not only to strike down a half-century-old federal law, but to cast doubt on about 36 state laws as well, and in doing so, to disregard what legislatures have done since the 1850s. So for the vast majority of American history, that's not a historical approach, that's an ahistorical one. This court should reject it.
How do you apply the fact that, as I recall from these various laws about the militia, and they had to show up with a smoothbore musket or a rifle or something else? They don't mention pistols in the types of weapons you're supposed to report for duty with. Do you see that as favoring your position?
I do, Your Honor. I think that's consistent with our view that these militia laws just do not imply the sort of right that plaintiffs would like them to. The fact that you showed up with a smoothbore musket to drill on the village green under the supervision of a militia officer, that does not imply that when you go home, you had the right to go and get a handgun against your parents' objection. The one just does not follow from the other. And really, that gets to a common theme throughout this history here, which is parental supervision. Of course, with respect to this statute, we know that Congress was concerned with making sure that parents could supervise 18 to 20-year-olds' access to handguns. We see that also in the 19th century sources. Many of those limit the sale of these weapons to 18 to 20-year-olds, but have an explicit exception for parents. And of course, that theme is continued in the militia laws that we just discussed, Your Honor.
How is parental supervision served by the rule the government wishes to have?
So, Your Honor, the history behind this statute when Congress was considering it in 1968 was this concern about a rise of handgun violence at the hands of 18 to 20-year-olds. Congress didn't want to cut off access to handguns altogether. The statute doesn't bar possession of handguns. What it does is say if you're—
But it's not served today.
Sorry, Your Honor?
Seems like having your cake and eating it too. That we look at this period after the founding, but we can't look at the current period, but we can only look at the period after the 14th Amendment, and say, well, it's parental supervision, or 50 years ago, because there isn't really parental supervision for the 18 to 21-year-old, is there? So we're having discussion about some reason that's not actually there.
So, Your Honor, are you asking about parental supervision today or at the founding?
Right. Well, it's not at the founding. I mean, the only supervision at the founding was that they needed to make sure they had access to guns. But so you're talking about in the 1800s. But anyway, but go ahead.
So,
For today, how is the government's position served today? And does it matter for your understanding of this?
So, Your Honor, I think what's important is to focus on what Congress designed this restriction to do, and that was, again, not as plaintiffs say, to ban access to handguns. That's just not what this does. It allows a parent to go and buy a handgun and provide that to their 18 to 20-year-old child. That's the parental supervision that Congress had in mind. That's the parental supervision that we see in the 19th century laws that we've relied on as well.
Can an 18 to 21 make their own 3D printed gun?
Your Honor, this restriction does not bar that.
Right, so they can buy it in the trunk of the parking lot, perhaps, from a non-dealer?
No, they go out and they steal it when they go into people's cars in San Francisco. So really, I don't see that parental supervision has a whole lot to do with this.
So, Your Honor, the fact that Congress might do more in the directions that these questions suggest, that's a policy issue, but it's not a Second Amendment issue. The Second Amendment issue is a historical one.
Getting down, so you concede that for 18 to 21-year-olds to purchase guns in a store is presumptively within the scope of the Second Amendment. Is that what you're conceding today?
Absolutely not, Your Honor. We haven't conceded that. If you look at
You haven't argued that yet, right?
Your Honor, the text step and the second step of Bruin, both of them are informed by the historical tradition that we're talking about today.
Well, the second part of Bruin says, post-ratification, adoption, or acceptance of laws that are inconsistent with the original meaning of the constitutional text obviously cannot overcome or alter that text.
That's right, Your Honor. Bruin and Heller both also spend a great deal of time analyzing this 19th century evidence.
So isn't it if 18 to 21-year-olds presumptively could use firearms or were required to use firearms participating in the militia from and before 1791, then they had a right to bear arms, to keep individual arms, did they not?
That's not right, Your Honor. So a couple of different premises that are incorrect there. One, this idea, as we've discussed, that having to serve as part of a supervised militia somehow applies a right outside that supervised context just isn't correct. This idea that the Second Amendment should be tied to militia service also isn't correct. I mean, militia ages sometimes went up to 21, sometimes went down to 16 or 14.
Well, that argument is totally untenable to me because the whole point of Heller was to say that the Second Amendment is not only the militia, it is more than the militia.
So, Your Honor, respectfully, that's not how I read Heller. I read Heller as saying you cannot look to the scope of the militia.
It was the right of self-defense that pre-existed the Constitution, that what Heller is talking about.
That's absolutely right, Your Honor, and that's why we need to look.
And the militia is part of the right of community self-defense.
Your Honor.
You can't disprove. There may be other parts of your argument that would appeal to the Supreme Court, but you just cannot deconstruct Heller in the way that you're trying to do it in order to show that there was no original right to own, to purchase firearms at the time, at 1791.
So, Your Honor, I think you've heard my arguments on this
Yep.
militia issue. I did want to address, I think one of the earlier questions was getting at 19th century laws and the weight that should be placed on those. Heller and Bruin, of course, both look at those laws and consider them carefully. That's consistent with what the Supreme Court has done in other constitutional contexts. It looks at the history both from the founding and from later and finds a common thread that puts it all together. We've presented a common thread here, which is parental supervision. Under plaintiff's theory, the Second Amendment meant one thing in 1791 and then meant something totally different at the time of the ratification of the 14th Amendment in 1868. That's not a plausible theory of history, especially because Bruin has said—
The 14th Amendment, as he pointed out, has nothing to do with federal legislation.
Your Honor, Bruin says explicitly that the meaning of the right to bear arms under the 14th Amendment and the Second Amendment has to mean the same thing.
Yes, but, you know, what I find limiting in that argument is the fact that, again, you don't need to deal with the 14th Amendment. We can look at the state legislatures as some imputed evidence of the federal government, but it wasn't until Gitlow that the Supreme Court thought that the 14th Amendment incorporated any of the Bill of Rights.
So, Your Honor, with respect—
That's reading back doubly, it seems to me.
Your Honor, with the reason I think that Bruin and Heller both take state legislative decisions from this era seriously is that in many states there was an explicit right to bear arms in the state constitution, and so the legislative enactments
But they were still both, local ordinances. They were not federal laws. And the Second Amendment, as originally promulgated, was directed to against the federal government.
Of course, Your Honor, our point is that the Second Amendment and the 14th Amendment have to mean the same thing. The Supreme Court has told us that, and so this idea that
They told us that because of the incorporation doctrine. I mean, your state law may regulate pharmacies, but the federal law controls because the federal government has separate authorities in certain respects. You don't interpret the limitations on state law against the federal government or for the federal government,
Your Honor,
except by analogy.
Your Honor, Bruin makes clear that there is one right to bear arms, both with respect to the states and with respect to the federal government.
Well, we'll find out more about that particular argument in Rahimi, won't we?
That's right, Your Honor, and I think to the extent that the court has questions about some of this historical methodology, it would be appropriate to hold this case for Rahimi. Obviously, that will be argued tomorrow. It will be the Supreme Court's first opportunity to squarely address restrictions on categories of individuals, and I'll note that the en banc 11th Circuit has chosen to hold a Second Amendment challenge to a state age-based restriction where the age is 21, pending Rahimi. So it would certainly be appropriate for this court to take that course as well. I did want to address plaintiffs' arguments about sort of 18-year-olds today and how they're treated. Of course, for many dangerous activities or potentially risky activities, legislatures continue to set the line at 21 for things like smoking, drinking, and gambling, so that historical norm persists. Also, 35 plus states have laws similar to this 50-year-old federal restriction. With respect to their argument that 18 should be the line and the only line that's permissible today. I mean, under that theory, this law was constitutional in 1968 when it was passed. It somehow became unconstitutional in some states as they revised their ages of majority, and then those ages of majority went back, it would become unconstitutional again. That's just an extraordinarily unstable view of the Second Amendment. I don't think it's what the Supreme Court had in mind in Bruin. In other words, as I think one of the earlier questions suggested, plaintiffs say that our 19th century evidence comes too late, but then they want this court to rely on late 20th century evidence. That's not a internally consistent approach. It's certainly not consistent with the historical approach the Supreme Court has taken.
Well, at earlier points, the government has observed that when there became regulations preventing blacks from owning guns, that those were useful to show limits on the right of ownership. And similarly, nobody would attempt to do that today, right?
So, Your Honor, in this case, we haven't relied on the laws that you've mentioned.
Well, you did make the argument that the people of the United States did not include 18-year-olds.
So history, Bruin tells us to look at history in defining the people, and what history shows is that with respect to arms
You know,
bearer-
that's basically the 1619 view, which I, for one, do not adopt, because if your argument is the people was only 21-year-old males, white males, then you're excluding women, you're excluding blacks, you know. Now that's not what the Constitution was, right?
Of course not, Your Honor. As history has gone on, subsequent constitutional amendments have ruled out categories that were drawn at the time of the
Well, I'm
founding.
glad you're eliminating that as an argument here.
Your Honor, we again, as I said, we haven't relied on it here because we have this much more specific set
Well, I
of
think it
laws.
was in your brief, actually.
Your Honor, I think we've principally relied on the age restrictions that closely parallel the federal restrictions that are issued here. We ask that the court affirm.
Okay, thank you. Mr. Ohlendorf?
Thank you, Your Honor. Just a few additional points, and I'd like to start by kind of situating where I think the disagreement between me and my friend is this morning in terms of Bruin's inquiry, because I think he made a couple of attempts in response to your questions, Judge Jones, to suggest that they do have an argument at Bruin Step 1. But I think really our disagreement is basically entirely at Bruin Step 2, because the way, at least that I read Bruin, is that Step 1 is a plain text inquiry. Now, it looks at history in the sense that the plain text meaning we're trying to figure out is the meaning in 1791, but all of these arguments about historical exclusions from the people, late 19th century traditions, that all goes not to the plain meaning of the Second Amendment's text. It goes to whether the government can bear its burden under the second history and tradition prong of Bruin. Second, turning to that prong, my friend's case is really built entirely upon these late 19th century laws that start in 1856. He says this is within the lifetime of the founding. Well, Adams and Jefferson died 30 years before that. James Madison died 20 years before that, so I'm not sure which founding it's within the lifetime of. My friend also suggests that, well, Bruin and Heller give equal weight to this later 19th century evidence, and certainly the court does consult in Heller and Bruin and Gamble in other cases later evidence as confirmatory, as kind of a gut check to confirm its reading from the founding era sources. But Bruin says this. It says, as we suggested in Heller, late 19th century evidence cannot provide much insight into the meaning of the Second Amendment when it contradicts earlier evidence. Now, that was the case in Bruin, and that's the case here. My friend said they don't have any earlier evidence. Well, we have the same evidence that the court had before it in Bruin. We have 60 years of zero restrictions, zero age-based restrictions on 18 to 20-year-olds keeping and bearing arms. That means we have a 60-year tradition of all 18 to 20-year-old Americans freely keeping and bearing arms. We also have, as you discussed, Judge Jones, we have the militia laws. And the militia laws show us that certainly 18 to 20-year-olds had to have been considered part of the people protected by the Second Amendment's individual right. And I read Heller exactly the same way you do, Judge Jones. Certainly it says that the Second Amendment protects an individual right that's not limited to militia service. But Heller also says there has to be a link because we know from the Second Amendment's prefatory clause that the very purpose that that individual right was codified into the Constitution was to prevent the disarmament of the militia. And Heller says the way that it did this is it protected the militia by keeping the government from disarming the very people from whom that militia would be drawn from. And it necessarily follows from that if someone was a part of the militia, then they're part of the people that were protected by the Second Amendment's individual right, because otherwise the individual right wouldn't serve that purpose. So there's not a confusion of rights versus duties here. The duty of militia service under Heller's approach shows us at least how far the right has to expand. Now, the people includes more than just the able-bodied white men who are in the militia, but it necessarily includes those. He mentioned briefly the fact that the handful of states required parents to provide the arms for their children, but presumably that was because some of these children were within the care and custody of their parents, probably were not financially independent. Where are they going to get the money to buy firearms if their parents don't provide them for them? This was, if anything, these laws cut my way, because they show that the purpose of these militia laws included guaranteeing that these 18 to 20-year-olds would be able to acquire the arms that they would then bring with them into militia service. My friend also attempted to justify Section 922B1 and C1 as empowering parents, protecting parental supervision. I think as a matter of fact, Judge Elrod, it doesn't do that for the reasons that you discussed in your colloquy with him. I think that also simply is legally irrelevant here for three reasons. First, we agree that the founders certainly viewed parents as having very robust authority over their minor children, but the government does not cite any actual firearm restrictions that were based on those sentiments, and that's what it has to do under Bruin. It has to come up with actual historical firearms regulations. And then just a final point on that, it doesn't have any purchase here anyway, because my plaintiffs are legal adults. My plaintiffs are not within the care and custody of their parents. Thank you, Your Honors.
Okay, thank you.